I'm Gregory Dell with attorneys Dell and Schaefer, and I'm here today with attorney Stephen Jessup. And today we are going to discuss the application process for whether it's short-term disability or long-term disability benefits. I can't begin to tell you how many people call us with regard to the application process for disability benefits and have the impression that it's going to be as simple as just filling out the paperwork that the disability carrier sends them, and then their claim is going to get approved. And I can assure you that the application process is nothing like the process when you applied for your benefits. As you probably recall, when you applied for your benefits, all you had to do was basically put down your name, your address, your date of birth, maybe some doctors you've seen, and within a couple weeks, or some of them if you're on a group policy, you automatically got approved for long-term disability, and that was it. Well, we're going to talk today about things that you should expect with this application process, and I think you're going to learn that it's a whole nother ball game. Now, every year we represent hundreds of people with their claim for long-term disability benefits as basically your consultant, so that we make sure you dot every I and cross every T. But we want to make sure you know what's at stake here so that you don't make any mistakes and avoid a possible delay or denial of your long-term disability claim. So Steve, can you talk a little bit first about what's the first thing that a claimant's going to get when they notify the disability carrier of their claim for benefits?
Well, the insurance company is going to send you out a standard packet of forms. You're going to have your claimant statement, which is your statement that you're writing about yourself, what the issues are. The attending physician statement to be filled out by your doctor, obviously. If it's a group policy through your employer, more often than not, you'll see an employer statement where your employer has to fill that out, and then an authorization to obtain information. Each one of these documents have their own special nuances that need to be, really focused in on. There's certain things to be aware of that if you don't want the insurance company to know, to try to limit in that. Your claimant statement, for example, will be lengthy, maybe 2-3 pages. However, the room that they're going to give you to actually try to explain what's going on may be a line or two. Most people can't even usually fit in with their own handwriting. And then the attending physician statement, obviously, you may have a physician. There's a good chance he's filled these out before, but he may not have. And the insurance company is looking for specific things on those forms. So the attending physician statement is really what gets the ball going. That's where they're going to really start trying to take a look as to what the possibility avenues of denying a claim really lie.
Right, and I think you said with the claimant statement, how often do you see where they have like one little line that's like half an inch and it says, what were your occupational duties? And then they want you to summarize your whole work that you were doing within one line of text, which is kind of impossible to say your job in one line of text. And then when they go ahead and evaluate the claim, they say, oh, well, you didn't really tell us about what your occupational duties were. And the disability company doesn't have any understanding as to what your occupational duties were, which is especially important if it's about being disabled from your inability to perform the duties of your occupation.
And an important thing to be leery of and cognizant of is the insurance company, their claims manager, who they always come off very friendly, and a lot of them are friendly, but they do have an agenda, will say, well, don't worry about that so much. We can get a job description from your employer. Then after the fact, if there's a denial and we get the claim file, you see that job description, which is usually a couple bullet points that are so generic you could probably apply it to any job. So that's really important too, to fit those occupational, get the occupational description in as thorough as possible.
Right, now I probably should ask you before we even talked about what a claimant should expect once they call the carrier is about when should the claimant call the carrier. Now, obviously we know the policies have notice requirements, but I would tell anybody who's calling me even before they're thinking of filing that don't call the disability carrier until you basically have all your ducks in a row. Which means that you know that your doctor's going to support your claim for disability, that you know that your employer is going to provide the documentation that you need. So many people have even called and said, I called the disability carrier because I happen to know their name, but I haven't even seen my policy. So you have to first really understand what the definition of disability is in your policy before you call the carrier, because as we've discussed in other videos, the moment you call a disability carrier, their goal is how quickly can we get you back to work, not how much can we find out if you're really disabled. They are all trained to say return to work, and they want to get you back to work within 90 days, which is usually the elimination period, 90 or 180 days on a long-term disability policy. So you have to be very smart and strategic as well as when you call the disability carrier, because the moment you call them, they're going to start calling you for information. I mean, Steve, how many people have called you and said, yeah, I called the disability carrier and they've been hurting and had limitations, but they haven't even seen a doctor yet.
Mm-hmm. It's
So,
true. It's true.
and with a group policy, if you're not disabled during the time in which you're employed, then you're never going to get approved for coverage. So there's a lot of things you got to be aware of before you even consider calling the
And I
disability
think it's
carrier.
important to reiterate the one thing you said. If you're thinking on going on disability because it hurts too much, especially on a group policy, do not quit your job and then try to file after the fact. The insurance company's right away going to say you weren't even covered under the policy anymore. The policy's there to protect you for those reasons, so make sure you don't terminate yourself from your employment prematurely. I had that happen recently, and it was detrimental to the entire claim.
Right, and that person can, that's a person who should call us because they have FMLA, the Family Medical Leave Act options. They can go on sick leave and they can protect their job possibly without the ability of their employer being able to fire them. And they keep their long-term disability or short-term disability policy, which keeps their options open. So, so you go through this process, you get the claim forms, and I'm assuming then you request all the medical records and you review all the medical documentation, you review the employer statement, you review the claimant statement and the authorization, then you send it to the carrier. What's the next thing that a claimant can expect?
Well, you're going to get a welcome, hi, I'm your claims manager letter, and then there's probably going to be, we've opened up the claim, we're starting review, but they're going to start requesting additional information. And a lot of times people will say, well, why do I have to give that to them? I don't want to give that to them. And there's certain documents that you can almost guarantee they're going to want. For instance, there's tax records. If you have profit and loss statements, if you own your own business, your own practice, whatever the case may be. If you're a doctor or a dentist, your production reports. These are all things that are very important to start getting ahead of time, because a lot of people will call sometimes, I filed my application 60 days ago and they haven't made a decision on it yet. Well, a lot of those other items needed haven't been submitted yet. Your claim forms aren't the end-all be-all when it comes to, okay, now they're going to evaluate, the time's ticking for them to. There's going to be additional stuff, even copies of passports. So it's always very important to have everything, as you said, your ducks in a row. That way when the submission of the application goes through, you're giving them all that information right away. You can expect they'll probably contact you if maybe have someone come out and try to visit your home. We have videos on that, or even a telephone conference, just a kind of initial meet and greet with you.
Right. I know whenever we submit our applications for our clients, from probably over the couple thousand applications that we've done, we anticipate every single thing that a disability carrier is going to request, because that they're going to ask for more documents. So we try to get every single thing under the sun from our clients, have it ready to go, often send the disability carrier more than they want, because every time they ask for a document, there's a lag time. Oh, we need this document. Then the claimant has to go find it. Then you get it back to the disability carrier. Well, keep in mind, you're not the only claimant that the disability carrier is working with. So every time there's a delay, they usually take 15 to 30 days to respond to whatever you send them. So they need 4 documents that you didn't send them, and they keep asking for more and more. You keep adding 30 days. Now you're 120, 160 days past when you were supposed to get benefits. In the meantime, you have no income coming in, which is ridiculous, and the disability carrier is still not paying you, and there's very little you can do because they haven't made a claim decision yet. So we try to always avoid all of those things and get everything in right off the bat.
And another thing I'm sure a lot of people have recognized is some of the insurance companies will fax you their letters. I swear they must have a different rate with the post office, because they'll send a letter and it'll be stamped into the office, a week, 10 days after. For some reason, it takes forever. So it's like they prefer to mail it knowing it's going to take that much time. Then you have to gather everything, mail it back, and like you said, you're looking 3 weeks, 4 weeks additional time getting back and forth. So it's always really good to be as prepared as possible.
The other thing you talked about was the phone calls from the disability claimant from the carrier to the claimant, or possibly wanting to do an interview with them. And I know that whenever we represent clients, we tell the carriers right from the get-go, you're not to have any communication whatsoever with our client. All communication is supposed to come through us. The reason for that is that the disability claims adjusters are trained to ask you specific questions, and you don't want to put yourself in a position where you're speaking to them not knowing the significance of every single thing you're saying to them. So anytime you represent a client, all phone calls, all letters, everything comes to us. Nothing goes to our client. And you really want to be very cautious whenever you speak to a claims adjuster. And I tell everyone, even if they're not represented, never speak to them on the phone. Always deal with them in writing. You're not required to speak to them on the phone. If they want to interview you, it's questionable whether or not you even need to do that. You should still probably deal with them in writing, but never speak to them, on the phone, because they're going to write down things and you're not going to know what it is. Because when you ask them for their notes, they're not going to give them to you.
I love nothing more than a nice paper trail.
Okay. Steve, another thing I wanted to bring up is I often find that it's taking a minimum of 60 days to 90 days for a disability carrier to make a decision, and clients always say, hey, how long is this going to take? Well, once the disability carrier gets all of the information, the entire claim packet that a claimant sends to them, why does it take another 60 or 90 days for a disability carrier to make a decision? What are they doing?
Well, they have their own internal things going on at that point. Obviously, every definition of disability in any policy is going to have two main requirements. There's a medical condition that's causing some type of restriction and limitation, and then how those restrictions and limitations, your condition, are affecting your ability to do your job. So the insurance company, the claims manager obviously isn't a doctor. What happens is they get that, they send it out either internally to a nurse case manager, their own doctor. They may send it out for an independent peer review doctor to take a look at it. At that same time as well, they're going to send it for a vocational review. They're going to try to determine what the duties of your occupation are. This is usually what you're seeing if there's going to be a denial letter where they just try to minimize what you do as either sedentary, light, medium. They love to try to throw everything in sedentary and light as much as possible. So the claims manager has all this going on, and like you said previously too, you could be one of hundreds or thousands of claimants at that time. So the claims manager is ultimately going to be the one who's going to make the decision as to whether or not benefits are going to be approved, but they need to rely upon the medical review done by their own doctor or whatever doctor they may hire, or and also the vocational rehabilitation consultant, and they might even send you out for an independent medical evaluation, which we have plenty of information on that on the site. So they're waiting for all that to come back, and then they're going to do their final review. That's why it can take so long. I know you submit this stuff, but the process, it is rather lengthy, and but the important thing to mention, it's once everything they requested has been in. If there's still one piece of information, they'll hang their hat on that and hold up the process even more.
The last thing I want to discuss about the application process is that some people call and say, is it an advantage or disadvantage to have an attorney? Is the disability carrier going to look at my claim differently by having an attorney? And, I always tell the clients that this disability policy you have is a contract, and if you're supposed to get $3,000 a month and you're 50 years old, and that's going to be $36,000 a year times the next 20 years, you're talking about hundreds of thousands of dollars are at stake. It's kind of the same thing as if you were going to try to buy a house and not have an attorney advise you. As an individual claimant, you're not skilled in knowing all of the terms of your particular contract. So to not have a lawyer advise you, you're at a significant disadvantage. The other thing is that these claims adjusters, they review the claims and they kind of gather everything, but then they go to their supervisors, directors, and their attorneys to advise them as to what their rights are under the contract. So by not having an attorney, you're at a significant disadvantage. Also, we go around the country to conferences where the insurance adjusters are there, and we speak to insurance adjusters all the time, and we find that they prefer to have an attorney on the claim because they know that we as attorneys know what they're entitled to get and what they're not entitled to get as documents. So it makes for the claim to go a very smooth process because we don't argue with the company over things that they're entitled to have. And because of that, we're able to get claims approved in a more expedient fashion. Also, all of the disability companies for the most part know that if they play games with any of our clients' claims, that we're going to hold their feet to the fire, whether that's in an ERISA appeal or a lawsuit or an individual disability lawsuit. Whatever it takes, they know that we'll have to do that. And through handling all of these claims and through battling some of them in courts, we've gained their respect that they know that we mean business with our clients' claims. So from that perspective, I think the clients have a big advantage in having an attorney, and certainly for someone who has hundreds of thousands of dollars at stake, it really doesn't make sense to not have someone who is advising you on your claim. If at any time you have a question about your claim, whether you're considering filing, you're filed and waiting for a decision, you're already on claim and the disability carrier is continuing to give you a problem, or you don't trust them, or you want assistance with your claim, feel free to call us at any time. We always provide a free consultation, and we welcome the opportunity to speak with you.